employers lack a clarity around employee classification that can cause employers to be fined or to face legal ramifications. So today's briefing is going to discuss a critically important issue of this a critical important piece of this larger issue, and that is the implication of employee misclassification on the long-term care and nursing workforce. When I was growing up, I wanted to be a nurse and worked my way through college in a nursing home, and so I learned a little bit about what they do. But North Carolina is home to more than 100,000 nurses who work each day to keep members of our community healthy. And I've always been inspired by nurses. My sister struggled with sickle cell anemia and passed away 2 weeks before her 27th birthday. Of course, back in those days, we didn't know as much about sickle cell as we do today. But I did see firsthand how much love our nurses pour into their professions and into their patients. Similarly, since the height of the coronavirus pandemic, America has seen our nurses and the health workforce fight tirelessly to combat the health crisis. We could not have made it through without our health professionals and our nurses. And so the pandemic brought with it a shift in employees' attitudes and workplace norms. And of course, our healthcare workforce is no exception to that trend. We've seen hospitals and physician offices adopt new telehealth protocols, ensuring accessibility of care for more patients. I had a number of meetings with my doctors sitting at home on my computer. But we've also unfortunately seen doctors and nurses alike face turnout from the surge of patients to their medical facilities. The realities of increased innovation and increased demand have contributed to the massive shift of nurses who are moving into more flexible or temporary nursing roles. And what has been challenging about this change for many is that it can be difficult. It can be difficult to determine whether these flex schedule workers should be classified as 1099 workers or independent contractors rather than employees. And that determines whether workers are entitled to certain benefits or other considerations. And we had a serious discussion yesterday in committee about this. Now, to have a strong workforce, of course, we must have a protected workforce. And as a Congress, we have a part to play in ensuring these protections for our nurses. And so to all of you who are gathered here today to certainly learn more than you knew when you came in, I'm sure. Thank you, and thank you for your bosses for prioritizing and making time to learn about this important issue. I always like to say that knowledge is power, and that's what makes the difference in lives and communities. So thank you all for being here. I know that today's briefing and panel discussion it will be a great step in the right direction for ensuring the rights of this vital workforce. I appreciate the opportunity for all of the seeds that these folks are going to continue to plant, because somebody once said that a community can only grow great when old men and old women plant trees under which we know will never sit. We're going to leave the shade for so many people. Thank you so much for having me this morning.
I'm hoping you can provide an overview of the current temporary staff nursing scenario in the market in terms of W-2 and 1099 workers, particularly the rise of online staffing platforms and the shift we're seeing towards temporaries being classified as 1099. Can you take off on that?
It's no secret that in the last several years, in connection with COVID-19, we have seen an increased demand with respect to temporary and contract nurses, nurses' aide, healthcare professionals generally. At the same time, there's no secret about widespread reports. We have a nursing shortage, we have healthcare professional shortages. And it has really created a challenging time for staffing firms, staffing agencies that are called upon to provide just-in-time professionals who are dedicated, caring, and so proficient at their jobs as a means of expediting the placement of these individuals, these healthcare professionals, we've seen an increase in the use of online platforms, Jim. And what do I mean by online platforms? I think we need to define terms. And it's really technology that serves to efficiently match nurses, aides, healthcare professionals, their interests with interest in temporary jobs and contract placements, and match them with hospitals, nursing homes, long-term care facilities that have a need for workers. Technology is fast, it's efficient, it's needed, it has a place, and it will be essential as we continue to go forward to meet the needs of the healthcare profession. An interesting phenomenon is that some of the online platforms have classified their workers, nurses, aides, as independent contractors, also known as 1099s, which sort of goes against the grain of what has been historical practice in the staffing industry. That is to say that most staffing firms, traditional staffing firms, brick and mortar staffing firms, many of which you've heard of, classify their workers in the healthcare space and outside of the healthcare space as employees, also known as W-2 employees. And so Senator Daschle said something that I completely agree with. This is an interesting area that is defined by legal tests that can be murky. There are many legal tests under various laws to determine whether someone is properly classified or not as an independent contractor or an employee. Many factors, and the facts and circumstances of any given case will determine the outcome, whether they're classified correctly or not. So an important question to ask in this context is, okay, we are placing thousands of healthcare professionals. Are they an employee or are they really an independent contractor? And if they are an employee under the various tests of the law, who employs them? In other words, who are they an employee of? The online platform or the client, the hospital, or the long-term care facility where they're placed? Now, I said, and Senator Daschle said, you know, it's complex, it's facts and circumstances based. Regardless of whether they are, these workers, independent contractors of the online platform, and in some cases they can be, depending on facts and circumstances. In my opinion, it is a very difficult argument to make that they are an independent contractor with respect to the hospital or the nursing home where they are working and placed on assignment. Unlike the gig economy, when people think of the gig economy, they think of typically Uber and Lyft, right? Drivers. When I get into a car with Uber, I'm not supervising that driver, and if I am from the back seat, I'm in trouble, right? This driver, he or she knows what he or she's doing. In the healthcare space, it's a highly regulated space. So if you have a nurse or a nurse's aide who's going to a nursing home and taking care of patients, that individual is following the direction and control of the nursing home or hospital for patient care. They're following the policies that are established. There's someone overseeing them. And one of the critical things under all these various laws that we're talking about to determine whether someone is an employee or an independent contractor, one big factor is direction and control. If they are acting autonomously, a physician, for example, or an advanced practitioner, if they have a significant training and really are acting autonomously, greater the likelihood that they could be classified as an independent contractor. Contrast that to nurses and nurses' aides, again, in a really controlled setting where we're talking about life and death outcomes. They are not acting autonomously. They're doing a wonderful job. I'm not trying to cast aspersions, but I am trying to focus on the nature of the relationship. And by virtue of the fact that they are following directions, they're following policies, they are reporting up the chain of command and following directions, I think it's very, very difficult to make the argument that, at least with respect to the facility where they're assigned and working, that they're independent contractors. Much, much more likely that they're employees.
Excellent point. Excellent point. And I'm glad you brought us to that point, because Sadie, I'd like to bring you into this because you worked for both W-2 and 1099 platforms. Do you notice much difference in the nature of the work when you've been between these two?
No, I feel the work is exactly the same. We report to a supervisor. We accept shifts that have set start and finish times. We take our breaks when they allow us. Also, we wear the scrubs they request. We follow all their procedures. It's a very controlled environment. Also, like for example, if you're assigned patients, you're required to take vital signs. Vital signs, I'm just so used to working. Vitals, using the facilities process. Whether you're a W-2 or 1099, there is no difference in what we do, how we do it, while on the job.
And are you working for both now, or how do you arrange that?
I did before for a while, but I found that 1099 option to be very hard. It's hard to keep up with the taxes, also the workers' comp insurance, the liability that comes with it. At first, it seemed, wow, this is great, 1099, I'm getting a little bit of a higher pay. And then after a while of being on the floor and taking care of patients, and then the outside life you have with children, relatives, parents to take care of, you have responsibility. And then I find that it started to become difficult for me being a 1099. Whereas to W-2, I started to be a little bit more comfortable with that, and it was easier to process and do my taxes, and it comes with, the liability, with the insurance, what they offer.
Krista, I'd like to turn to you. From a policy perspective, can you tell us a little bit about the rise in 1099 temporaries and how that might be impacting, like we said, patient outcomes?
Yeah, exactly. So to pick up on what Stephen had mentioned earlier, over the last 2 decades, we've really seen a tremendous increase in the rate of contractor workers. So we see that there's more employees who have independent contractor income. We also see that more firms are using this type of worker. And in large part, that's due to the technology advances that Stephen and the Senator mentioned earlier. But it's also important to think about what types of workers are now being classified as these independent contractors. And some of the largest growth we've seen has been amongst the platforms, especially since the Great Recession, like Stephen pointed out. And we've also seen really tremendous increases amongst low-wage workers, especially in the healthcare industry. And there's also a gendered component to it, in the sense that many of these lower wage healthcare workers who are now classified as independent contractors are women or immigrants who already are tending to earn lower wages compared to other groups in society. So we've seen this increase, and so this begs the question that Jim presented is, what does this mean for patients, right? We know, we've heard from Sadie how this can affect workers, but there's also implications for the people that these workers are caring for. And we've seen in the long-term care sector that facilities that rely more heavily on independent contractors also tend to have worse patient outcomes. So there tends to be a greater share of residents who report moderate to severe pain, or have pressure ulcers, or are using catheters. And all of this is not causation, it's just correlational, but it does kind of raise these red flags that we should be thinking about how this transformation of the workforce might have spillover effects to patients. And more recently, during the COVID pandemic, some of you might have seen the study showing that workers who are working in multiple facilities, which is often associated with with independent contract work also had higher rates of COVID infection, which not only affected the patients that these workers are caring for, but also those in the surrounding communities. So I think, to Jim's point, this is an issue that affects not only employees and employers, but also the consumers of these services.
Yeah, some excellent points going right back to the start of the pandemic in the U.S., correct? Out in Washington, that's the first thing they pinpointed was the moving nurses and the nature of the work. So Dane, we'll come to you. This is really kind of where a lot is circulating in, the DOL's proposed rule. Can you outline for us a little bit how they're trying to address the issue of worker misclassification, some of the protections that misclassified workers might lose out on? Take us into that world for this.
Sure. And good morning, everybody. It's a pleasure to be here with you. The Department of Labor has always been interested in the misclassification of workers as independent contractors for various reasons. But in 1947, it was the Supreme Court that decided what the test was going to be under the FLSA, and it's the economic reality test. It looks at 6 factors, but those 6 factors are only meant to help a court look at the totality of the circumstances. Those 6 are not the only factors to be looked at, and none of them are to be looked at independently to be determinative. So although a lot of people look to the idea of how much control is being placed, that's merely one factor. And so what's happened, if you think 1947, the Supreme Court established this test. We have over 70 years of courts creating case law, analyzing all the various factual scenarios of how a worker is going to be properly classified as an employee or an independent contractor. So what the Department of Labor did for the very first time in January 2021, in the last days of the Trump administration, was issue the first rule that addressed independent contractors. When you look at the FLSA, it doesn't have a definition of independent contractors. It defines employee as an individual. That's a good start. So, but an individual, because a lot of times you'll see independent contractors who the employer helps them get an LLC or an entity, which most courts will disregard if it's just for the sake of having one person hide behind an entity. But employee is an individual who is employed by an employer. So it was a long time ago when people in this building passed the FLSA and gave us that definition. We might have wanted more, but that's what we've got. So for 70 years, it was left up to the courts to tell us and decide how that was going to be defined. In 2021, the Trump administration came out with a rule that altered a little bit. Instead of looking at these 6 factors as the main factors within the totality of the circumstances, they said, we really think that 2 factors encapsulate what the economic reality test gets to. And then maybe we'll look at 3 other guideposts if necessary. But they narrowed it in, and most people thought that was a fairly drastic shift from what the economic reality test is. The pending rule that is expected to come out now in the next couple of months is really just returning us to the original economic reality test, reliance on the 70+ years of case law that already exists. It's looking at the totality of the circumstances, still looking at those 6 primary factors, and the Department of Labor specifically says that that's why it changed its mind to that the 2-factor test really was going to cause more confusion than it would help. And so in the new rule, the Department of Labor returns to the old test, and the confusion in the economic reality test, if you think about having to take all the factual circumstances of someone's work life and try and analyze that, the way that it's analyzed by different courts can and is done in very different manners. And that's where the confusion and murkiness has always come in. So in the new rule, the Department of Labor has taken a number of the factors and tried to clarify what the department says is the correct view in how to look at a factor, such as control. So courts have gone both ways on whether or not if an employer merely has the right to control an employee's, how an employee does a job, does that mean that they have that right and therefore they're an employer? Some courts say yes, some say no, some courts say you must have actual control. So the new rule clarifies that as long as the employer has the ability to control, then that's going to indicate employee versus independent contractor status. So the takeaways on this, I think, are that independent contractor is not a new thing. I mean, we have a Supreme Court decision from 1947. We have a new rule, which is really just the old test. And I think it's important to, with everything that's been said today about particularly the lower wage earners within the healthcare system, CNAs, nursing assistants, under either test, it doesn't matter. It's nearly impossible to consider any of those entry-level, mid-level nursing positions as independent contractors working within a facility that is so highly regulated. I've said before that if you think about the industries, various industries, what industry is more regulated than healthcare? I mean, maybe a nuclear facility. But you're not going to get, as Stephen said, it may or may not be that the staffing agency is an employer of this employee, but the moment that employee walks through the door of a highly regulated facility, that facility is almost certainly a joint employer.
Well, that's actually a good segue. I want to go back to Stephen and say, having the rule is one thing, but enforcing regulation is another thing. What should providers, the long-term care providers, the hospitals, what should they be thinking about with regard to the risks involved here?
Well, I think they need to think about the relationship between themselves and the worker, whether they come through an online platform or a so-called traditional staffing firm, brick and mortar, to look at how this individual is being classified. And by the way, there is a misconception among some that the worker gets to choose his or her classification, which is not the case. I mean, it's a legal standard and legal tests, plural, to determine whether one is an independent contractor or an employee. So they need to look at, if someone's coming in their doors as an independent contractor, what their potential liability is if a court or an agency such as the Department of Labor decides otherwise, that is to say that they're an employee. So what is the potential liability? Well, certainly potential liability for overtime. There's potential liability for health and other benefits, workers' compensation, paid leave, unemployment benefits, payroll taxes, all of the responsibilities that a nursing home, long-term care facility, hospital has with respect to its own internal employees, it could be liable for with respect to these workers who are now assigned and working to them. So you might ask, Jim, or someone listening to this might ask, okay, well, kind of play out for me, Stephen, what happens if the online platform or the staffing agency classifies these workers as employees? Is there still risk to the nursing home or hospital? Well, potentially, but it's much, much lower. If the staffing agency, the online platform, classifies these individuals as employees, now all of the things I just talked about, overtime, payroll taxes, workers' comp, unemployment, that's all taken care of by the online platform or the staffing agency because they classified them as employees. So the risk to the nursing home or the hospital is much, much less.
That's why, Dana, I wanted to come back to you. Can you tell us a little bit how you're seeing this play out in the courts? Maybe a few examples of enforcement.
So if we think about the exponential growth that has occurred with independent contractors, so I think there's a lot of studies out there that find a lot of different numbers. I mean, McKesson will say we're up to 36% of the labor force works as independent contractors. The US Treasury says from 2001 only till 2016, we went up 20-some% in the number of independent contractors that were out there. So what we do know when you look at those, regardless of the number, is growth. The numbers are definitely going up. They're not staying static. And then if you think about the 2008 financial crisis, where everybody lost their jobs and had to figure out how to make some money, and then at the beginning of the pandemic, you had a similar situation. So you've had a couple of things in the economy that just pushed this along at sort of a hyper speed. And on the litigation side, the more independent contractors that we have in the labor force, the more litigation we're going to have over independent contractors, and that's exactly what has happened. I think interestingly in the healthcare field, the pandemic not only pushed a lot of people into independent contractor work, but because it caused such a tightening of the labor market, probably nowhere more so than in the healthcare industry, that it created the perfect storm or the perfect opportunity for these other staffing agencies that have a 1099 model to start providing workers to facilities that maybe would not have happened, or certainly wouldn't have happened at the rate that it happened if you didn't have facilities who were desperate for workers. So just like the facilities, hospitals that I represented were buying supplies from places they never would have considered buying supplies from in the past, they bought their labor from the same new places. And so we saw exponential growth of particularly of lots of different agencies, but these large, what we'll think of as gig or platform staffing agencies that have chosen to have 1099 nurses, they have seen unbelievable growth, and it likely wasn't possible without the pandemic. But today, this is where we are. They're enormous, with tens or hundreds of thousands of nurses being employed as 1099s, being placed in facilities. And so from my experience, both prosecuting these cases and also advising some hospitals or other facilities on this, I have seen the facilities have at least two different viewpoints. One is they think that, some of them actually think that if the staffing agency has a 1099 model, that they've done what's necessary and that everything is going to be okay. Which might, as Stephen said, might be true for the staffing agency itself. They may not be an employer. But that's not the same situation when that worker walks through the facility's doors and the facility becomes the joint employer. And the facility may be the only employer of that employee, and therefore the only person responsible for the overtime that you mentioned, the paid leave, any other employee benefits that they're entitled to as an employee versus an independent contractor. I think we also saw 1099s increase in more industries. It used to be a little more narrow in the number of industries where 1099s were common. Construction, of course, we had lots of it. So healthcare, as someone said earlier today, is a somewhat new phenomenon. And why is it that 1099s are showing up in more and more industries? There's no scenario under which the reason 1099s are used other than it saves the business using that worker money. There's no case under which, if every single business could employ 1099s, they would. The only thing that stops them from doing that is the law that says If you do it, you're going to have to pay consequences, which leads me to my last point, is that it used to be that you complied with the law because it was really expensive if you didn't. But after the Supreme Court's decision in Epic in 2018 that said that enforced all of arbitration agreements across the board, it's not quite the same case anymore. It's not as, private plaintiffs can't go and sue a large company, a large 1099 platform, and make them pay tens plus millions of dollars to correct the mistake. All they can do is bring an individual case to arbitration, confidential arbitration. So, as I say, you have a huge increase in independent contractors. We have a large increase in litigation. That doesn't even begin to tell the story, because we don't have the numbers on arbitration that's going on for litigation. And that is where the majority of litigation occurs now, particularly over independent contractors. Any large employer that's at all sophisticated is going to have an arbitration agreement in their independent contractor agreement, and it's going to have a class action waiver. So the only thing that employee can do is bring a lawsuit on behalf of him or herself. And if you're thinking about a company that's literally making tens of millions of dollars extra, not an exaggeration, tens of millions of dollars extra because they're 1099 instead of W-2, these dozens or hundreds of arbitrations are not going to put a dent in what they're capitalizing on. So the Department of Labor filed amicus briefs for years prior to the Supreme Court's decision saying this is exactly what was going to happen, and it has. So they said, if you enforce arbitration agreements in these employment agreements, and when you have an independent contractor dispute, the only party who can bring a case against the business to address that issue on across the board, enterprise-wide, is the Department of Labor. And the Department of Labor does not have the resources to do that. So prior to 2018, there's an enormous plaintiffs bar of wage and hour lawyers, and the Department of Labor relied on that plaintiffs bar to help ensure enforcement of the FLSA, and that's largely gone now, other than in the arbitration arena where everything is confidential. We don't know when a case is filed, and we don't know the outcome of those cases.
Stephen, I want to ask you, you've got 60 seconds. Tell me about how is ASA raising awareness on the issue at the federal and state levels?
Well, we're doing exactly what we're doing here today, and that is educating people about the issue. Issue spotting, presenting what we think is going on in the marketplace, what we think the law, where the outcome might be under the law. And we're actually, I think our position would be that it would be helpful for the Department of Labor to issue some guidance here in this area, because the legal tests are, as Dane said, multi-factor, they're complex, they're facts and circumstances based, but the Department of Labor should try to provide some guidance in our opinion. As we haven't even talked about the states. States have other legal tests, and some states, such as California, are much more stringent, and their tests are much more difficult to fulfill in order to be an independent contractor. So it would be helpful for not only DOL, but the states to provide guidance.
Okay, Krista, let's go back to that then on the regulatory level. What do you think the administration can and should be doing to curb this misclassification issue?
Yeah, so there's definitely a federal role. I think Dane outlined a lot of the legal issues really clearly. And I think we've also heard from all of the panelists, like, this is just a really complicated issue, right? And in the sense that many of these workers are working for multiple firms, it requires kind of a federal response. Like a worker might be working some hours in Oregon, other hours in Washington, and in order to make sure that this worker is classified correctly, we need to make sure that there's some harmonization that is able to bring together all of these different experiences that the worker might be facing.
Dane, I'll go back to you. Give us 60 seconds on, about employer risk again. How is it impacting withholding with the IRS? Those issues.
I think the IRS, the belief is that the IRS will get its money one way or the other, whether it comes from the employer or the employee. The reality is that, as Sadie said, an employer pays their portion of the taxes quarterly, and it generally gets paid. The employees working either as a new 1099 or sometimes even not really understanding that they're working as a 1099 have no idea what they need to be doing about their taxes until the end of the year when they get hit with that tax bill. So at a minimum, the IRS has got increased costs in trying to deal with a lot of workers who have found themselves in this position. They're not getting their money right away for sure. They might have to compromise it, and the amount of resources just to try and go after, at this point now, the potential, the business that might be the employer and or the workers who are now their own employer without knowing about it. The IRS is not getting their money nearly as easily.
Okay, interesting. And speaking of the nurses, Sadie, I want to go to you once more, and I think it's great to go back to the grassroots level. What are you hearing from your colleagues? Do they understand the difference between W-2, 1099? I mean, we really probably have to look at it from the core level before we start taking it all out, going back out the other way.
I think most of them think that the only difference is taxes, whether they are taken out of their pay or not. Like I said before, nurses and nurse aides are juggling a lot. They are on the floor, they're taking care of patients at work. It's literally a war on the floor when you are on the floor working. So you already have so much of that stress going on and the proper care. And then after that is the afterlife, afterwards, whether you have to study for a final, whether you're taking care of your children. I mean, there's a lot of single moms are on the floor. So they already have to go through a lot. So accepting 1099 shifts will become an issue when it comes to that. And I myself have seen it, because I did the 1099 shifts and I have done the W-2, and I've seen that it gets complicated and very hard.
Yeah, I mean, there you have it, folks. We've got some tough times ahead. We have to be very vigilant on what's coming, with the rule coming through, and the different things, as Stephen said, we need to be keeping an eye on. And I'm glad you were here to do that.